Welcome to Literary and Jury Charge Practice. Let's get started with a little warm-up. This jury charge is fairly short, just enough to get our fingers going. Ready? The test to be given to testimony is not merely the number of witnesses, but rather the weight to which the testimony of such witness or witnesses is entitled. And in determining this question of weight and credibility, you have a right to, and you should consider the conduct of the witnesses on the stand, their manner on the stand, their relation to the parties, if any, their degree of intelligence, their interest in the case, if any, their bias and prejudice, if any, the reasonableness or unreasonableness of their statements, the opportunity for ascertaining or being correctly informed as to the matters concerning which they testify. A witness is presumed to tell the truth. This presumption, however, may be overcome by the manner in which such witness testifies, as well as by other circumstances or conditions such as may be used in testing the credibility of any witness, as I have heretofore instructed you. If you are convinced that a witness has sworn falsely to a material matter, and being convinced that such false testimony was not the result of mistake or inadvertence, but willfully given with the design to deceive, then all of the testimony of such witness should be disregarded by you, unless such testimony or any portion thereof may be supported by other testimony entitled to greater weight, or for other reasons you may be convinced that the witness has testified truthfully as to a portion of his or her testimony. You should not consider any statement of an alleged fact made by counsel during the trial as evidence in the case, unless such matter is stipulated to as a fact by both sides. The only evidence that you can accept in determining the issue is that which has been produced from the witness stand or by stipulation of counsel for the parties, or such presumptions of law as the court may give to you, bearing upon the facts in the case. All right, hopefully your fingers are feeling warmed up. Let's move on to this jury charge regarding income tax evasion. Ready? Here we go. Money or property acquired by gift is exempt from taxation under the income tax laws. A gift is a voluntary transfer of property by one to another without consideration or compensation. Therefore, the principal consideration in determining whether or not a payment is a gift within the meaning of the Internal Revenue Law depends upon whether there was an intention to make a gift. The mere absence of a duty to pay does not necessarily make a payment a gift. Any payment as compensation for services, even though the payment is voluntary, is nonetheless income to the recipient. If you find it to be a fact that the Huntley Company charged to business expenses any payments that you may find to have been made to the defendant, you may consider that fact among other facts in determining whether or not the Huntley Company intended such payments to be gifts. If you find that any such payments were made as compensation for services rendered by the defendant, they are to be considered as being income to the defendant. A person cannot avoid taxation by arranging to have his earnings paid to some other person. It is not necessary that income be actually received by the taxpayer for it to be taxable to him. If a person arranges or directs that earnings due him be paid to some other person, he has nonetheless received income which he is legally required to report and upon which he is required to pay taxes. If you find from the evidence that payments were made by the Huntley Company in consideration of services rendered by the defendant in procuring the advertising account of Morrison Industries for the Huntley Company, and if you further find from the evidence that such payments were paid by the Huntley Company pursuant to and in accordance with the directions of the defendant, then you are instructed that the amounts so paid constituted income of the defendant which should have been reported by him in the tax years during which such payments were made. If, on the other hand, you should find, or if you have a reasonable doubt that the Huntley Company, at the times their checks were delivered to the defendant, intended to make gifts to the persons designated by the defendant, or intended that the checks were political contributions, then the amounts of such checks would not be income to the defendant, and income taxes would not be due and owing thereon. It is not necessary for the government to prove that the defendant received income in the exact amount stated in the indictment, or that the taxes due on his income were exactly as stated in the indictment. It is sufficient if you find, beyond a reasonable doubt as to any particular count, that the defendant received a substantial part of the income which he is charged with receiving, and failing to report upon his income tax returns, and that he willfully attempted to evade and defeat a substantial portion of the taxes due on such income. All right, now let's practice some literary material. This is one we had started called Most Simple Appears Too Simple. So we'll continue with this. Ready? Here we go. Many of the responses are profound. Many are gut-laughing funny. One person wrote asking how she could get the hair transplanted, which she had recently lost, working towards her goals. Another person shared proudly that she is a great reporter and a sloppy eater. She included eating soup as her sloppy lunch that day, but it will be great, and I will work on the new assignments you've given me after I finish my sloppy noodles. Simple is one step, focusing on the work and class dictation you are now producing each day. Start with simple. Broadcast captioners are captioning with outstanding translation rates each day. News broadcasts frequently lead with late-breaking news and the words "I dread," immediately moving to the edge of my chair. This just in. Programs, news and comedy lead with updated real-time stories about protests in Egypt and Afghanistan and current events in the Middle East and Europe. Before work and phrases remotely approach our American and Canadian borders. Within Texas, we listen to news anchors discussing freezing up pipes and changing up the running of water in outdoor pipes as temperatures reach historical all-time lows, and the yearly rodeos with free cowboy breakfasts and freezing temperatures create new scenarios, new words too. Just another day in the life of a captioner. Many times I have watched flawless captioning and listened to people commenting, "That must be a machine. It's perfect. I simply smile. I know each broadcast captioner works very hard to have the text words simply translate accurately across their screen. In my mom's multiple hospitals during December, January, and February, each time she was moved into a new room, I hunted for the control box, maybe in her bed, maybe on the bed's side panels, to turn on the captioning. Sometimes I stood on my tiptoes reaching up into the air for the older ceiling-suspended televisions. I was successful 100% of the time, while stretching and pressing every switch and every button. Once the captioners were on the television, nurses, aides, technicians, respiratory staff, housekeeping staff, and hospital crew trolled into Mom's room to watch. Small clusters of people in odd-colored shirts, many wearing tops with animals or flowers in bright pink or green, stood just steps within the doorway near Mom's sink. They huddled, leaning together as a group, peering toward the TV. I simply watched from my uncomfortable chair. I did not comment until I was asked, "What's that?" Not one person knew this could be viewed on the television in the hospital rooms, and many did not know they could do this in their home. I beamed with pride when people discussed all those words, how fast they come up, and they're correct. Go captioners. Yes, I had a few mini interventions sharing that patients and family members would benefit. Each time I was told, "Oh, we have children and adults who could use that." I did not sigh once, really. All right, we'll get back to that material. For now, let's try this jury charge on income tax evasion. We have another one here. We're going to know all about income tax evasion. All right, ready? Here we go. A defendant in a criminal case is not required to prove his innocence, but is presumed to be innocent until the contrary is proved. But the effect of this presumption of innocence is only to place upon the government the burden of proving a defendant guilty beyond a reasonable doubt. In common parlance, a reasonable doubt is just what the term signifies. It means a doubt that is based or founded upon reason. It does not mean every conceivable kind of a doubt. It does not mean a doubt that is imaginary or speculative or fanciful, nor is it a doubt that may be founded upon suspicion, surmise, or conjecture. It means an honest doubt that appeals to reason and, as I have said, that is based upon reason. Reasonable doubt has been defined as follows. It is not a mere possible doubt, because everything relating to human affairs and depending upon moral evidence is open to some possible or imaginary doubt. It is that state of the case which, after the entire comparison and consideration of all of the evidence, leaves the minds of the jurors in that condition that they cannot say they feel an abiding conviction to a moral certainty of the truth of the charge. The law does not require demonstration, that is, such a degree of proof as, excluding every possibility of error, produces absolute certainty, because such proof is rarely possible. Moral certainty only is required, or that degree of proof which convinces the minds and directs and satisfies the conscience of those who are bound to act conscientiously upon it. It is always difficult in everything relating to human affairs to prove a fact to an absolute or complete certainty. For that reason, I have instructed you that a reasonable doubt is not just an imaginary doubt or a bare conjecture or a suspicion or a surmise, but that it is one based on reason. This is called An Engineer Testifies. So we will learn some new terms here. Ready? The proposal was to put a row of heavy concrete piles along the west face of the building by drilling some borings which varied in diameter up to 42 inches and reinforcing these heavily with steel and tying the tops back by means of tie rods under the house to an anchor located to the east of the house. The lower portion of these piles was to extend deep enough into the underlying rock so that the pile would act as a beam for support and to compensate for a tendency of the soil to the east of the piles to move down the slope. Along the west side of the house was a connecting beam, and at each of the locations of the original piers, a strut was placed so that the foundation was prevented from moving laterally due to effects of the tendency of soil to move downward. It was then assumed that where it was necessary, the existing caissons would be cut off and the house could be jacked up until it was level. Then concrete would be packed above that. Now this design was based on a certain number of piles, and the piles would get shorter toward the north because the original idea or the original depth of the building piles was shorter at that depth. Therefore, we figured that we would need fewer piles and they could be of less diameter as we progressed from the southern portion of the house toward the north. That was the original scheme for supporting this foundation. After the two borings were made and it was discovered that the portion on the north side of the house, the portion of the fill on the north side of the house, was considerably deeper than originally anticipated, it became apparent that in order to successfully retain the fill material, it would be necessary to increase the piles. In order to ensure that the soil would be stable and that there would be no subsidence, it was necessary that these steps be taken. Lots of new terminology. Right. Let's just do a little bit more from our jury charge on tax evasion. Ready? As I have stated, the government is required to prove its case beyond a reasonable doubt, but the requirement of proof beyond a reasonable doubt is a direction to the jury, not a rule of evidence. It operates on the whole case and not upon separate bits of evidence, each of which needs not be so proven. Each item of evidence need not be proven by the government beyond a reasonable doubt, but each item of evidence is to be weighed by you by the same standards by which you govern your own daily affairs in the ordinary business of life. However, in considering whether the government has established a case for conviction, the evidence taken as a whole must convince you beyond a reasonable doubt of the defendant's guilt. Otherwise, you would not be warranted in returning a verdict of guilty. And we'll stop there. That will conclude our literary and jury charge practice.